Hi, and welcome to this first of 4 webinars looking at business and human rights in the digital environment. My name is Richard Wingfield, Legal Officer at Global Partners Digital. These webinars have been developed by Global Partners Digital in cooperation with the Global Network Initiative, Internews, New America's Open Technology Institute, and Ranking Digital Rights in order to introduce some of the key issues related to business and human rights in the digital environment. This webinar series comprises 4 webinars on different issues and an interactive question and answer session. In the first webinar, we'll be looking at business and human rights broadly, the major developments in the field, and the key actors. In the second, we'll look at the relationship between business and human rights and the digital environment specifically. Next, the Open Technology Institute will look at 2 priority issues in the field, privacy and freedom of expression. By the end of the series, you should be able to understand the key concepts, terminology, and principles in the field of business and human rights, as well as its links to the digital environment. Businesses can impact human rights wherever and however they operate, whether it's through the products and services they provide or their own policies and processes. Companies can impact the entire range of human rights positively or negatively, including the right to non-discrimination, freedom of association, freedom of expression, the right to privacy, as well as others. These days, many companies operate globally, and that means that their impacts are felt globally too. In recent years, there have been a number of high-profile instances of businesses impacting human rights in the tech sector. These include data breaches, companies sharing data without users' consent, censorship by online platforms, and companies assisting governments in online surveillance. All of these instances demonstrate the significant and widespread impact that companies' actions can have on human rights. Historically, however, the international human rights system didn't pay much attention to businesses. This is mainly because businesses don't have legal obligations under international human rights law. Since the 1970s, however, the UN has been increasingly interested in the impacts of businesses on human rights, and it's now widely accepted at the international level that businesses have a responsibility to respect human rights. A key milestone in this journey occurred in 2011, when the United Nations Human Rights Council endorsed a set of principles that define the responsibilities of governments and businesses when it comes to human rights. These are known as the UN Guiding Principles on Business and Human Rights. They're a set of principles that, while not binding, set out duties of states and responsibilities of companies. Let's take a look at the UN Guiding Principles. They're divided into 3 pillars. The first pillar, Protect, says that governments have to make sure that human rights aren't abused by businesses. This usually means passing laws that prevent human rights abuses and making sure that they're implemented. The second pillar, Respect, says that businesses have to refrain from causing adverse human rights impacts wherever and however they do business. That means that it's not enough for companies to simply follow the law where they operate. Even in countries where the governments don't fully comply with their own human rights duties, companies have to understand their human rights impacts and take concrete steps to address any adverse ones. The third pillar is about what happens when something goes wrong. If a company causes an adverse human rights impact, governments have to make sure that the court system or some other legitimate process allows victims to file complaints for these to be investigated and settled. Companies also have an obligation under the third pillar to make sure that they have some process in place to address any adverse impacts that they have caused. Each pillar comprises foundational principles that set their scope and operational ones that set out how they should be put into practice. During the in-person workshop, we'll go through these in detail, but for this webinar, we just want to highlight the most important ones. Let's look first at Pillar 1, the state duty to protect against human rights abuses by third parties. The foundational principles under Pillar 1 say that states must protect against human rights abuses by third parties, including business enterprises within their jurisdiction, by taking appropriate steps to prevent, investigate, punish and redress such abuses through effective legislation, policies, regulation and adjudication. This is Guiding Principle number 1. Guiding Principle number 2 says that states should set out clearly the expectation that business enterprises domiciled in their jurisdiction respect human rights across their operations. We'll look further at this in more detail during the in-person workshop, but it's important to note at this stage that the UN Guiding Principles take the position that states are not generally required to regulate the extraterritorial activities of businesses based in their jurisdiction. However, states are not generally prohibited from doing so either. As well as the foundational principles, there are also operational principles under Pillar 1. Guiding Principle number 3 says that states are required to take appropriate steps to prevent, investigate, punish and redress business-related human rights abuses through effective legislation, policies and guidance. Guiding Principles numbers 4, 5 and 6 say that states should take additional steps to protect against human rights abuses by business enterprises that are owned or controlled by the state or which receive substantial support from state agencies. If they don't, this may even amount to a violation of the state's international human rights obligations. States should also include human rights considerations in their procurement of goods and services. Guiding Principles 8, 9 and 10 say that within their national legal and policy framework, states should ensure policy coherence. For example, a state should make sure that the trade and investment agreements it negotiates are in line with its human rights obligations. Finally, Guiding Principle number 7 says that because of the heightened risk of gross human rights abuses in conflict-affected areas, states should take extra steps to ensure that businesses operating in these areas are not involved in human rights abuses. Since 2014, the UN Human Rights Council has strongly encouraged all states to develop, enact and update a National Action Plan on Business and Human Rights, or NAP for short, as part of the state commitment to disseminate and implement the UN Guiding Principles. The UN Working Group on Business and Human Rights, the Danish Institute for Human Rights, and the International Corporate Accountability Roundtable have highlighted 6 criteria for the development and implementation of NAPs. First, the process should be embedded in the government and be adequately resourced. Second, the process should involve all relevant stakeholders. Third, one of the first steps should be to create a national baseline assessment to understand existing gaps. Fourth, the NAP itself should address all 3 pillars of the UN Guiding Principles. Fifth, the process should be transparent. And finally, the finalisation of the NAP should be followed up by a monitoring and review process, including all relevant stakeholders. Since 2011, 21 governments have developed a NAP. And while there are a range of different ways that they've been developed, there are some good and poor practices that we can point to. First, the good practices. Most NAPs have been developed through the involvement of a range of relevant government entities during the drafting process, including the creation of interministerial working groups. Secondly, they've generally involved consultation with stakeholders. And third, many NAPs include information in relation to follow-up and the implementation of planned future actions. In terms of some of the weaknesses, the development of NAPs usually fail to include processes which allow participation by disempowered or at-risk stakeholders. NAPs also tend to lack transparency regarding the drafting process, with timeframes and terms of reference often not published. There's also a general failure to conduct national baseline assessments to inform the content of the NAP. NAPs are ultimately important because they can provide an opportunity for the constructive collaboration and dialogue between stakeholders that's needed for the effective implementation of the UN Guiding Principles. Let's turn to Pillar 2, the corporate responsibility to respect human rights. The foundational principles in Pillar 2 make clear that the responsibility to respect human rights requires business enterprises to avoid infringing on human rights and to address any adverse human rights impacts with which they're involved. This principle applies to all businesses of all sizes in all situations, and also includes all internationally recognised human rights. These are Guiding Principles numbers 11 to 14. In terms of operational principles, Guiding Principle number 15 says that businesses should have in place a policy commitment to respect human rights, an ongoing process of human rights due diligence, and processes to enable the remediation of any adverse human rights impacts that they cause or to which they contribute. Human rights due diligence, which is set out in Guiding Principles number 17 to 21, needs to cover different types of adverse impacts on all internationally recognised human rights. This includes impacts that the business causes, impacts to which the business contributes, and impacts that are directly linked to business operations, products or services. Actual and potential adverse human rights impacts should be avoided and addressed through human rights due diligence, which includes 4 key steps. First, assessing adverse human rights impacts. Second, integrating and acting upon findings in those human rights impact assessments. Third, tracking and monitoring responses. This should be an ongoing process involving affected rights holders and other stakeholders. And fourth, communicating and reporting. Information about due diligence and impact assessments should be publicly communicated. They should be accessible, provide sufficient and relevant information, and not pose risks to right holders or others. Finally, let's look at Pillar 3, remedies. Under this pillar, states and businesses are obliged to ensure access to an effective remedy for victims of business-related human rights abuses. This includes access to both judicial and non-judicial remedies. On judicial remedies, Guiding Principle number 25 says that a state needs to take appropriate steps to ensure that its legal system, including its national courts, is effective in addressing business-related human rights abuses. This also means that governments need to consider how to reduce legal and practical barriers that could prevent victims from accessing an effective remedy. Many of these barriers are the result of, or compounded by, the frequent imbalances between the parties to business-related human rights claims, such as in relation to their financial resources, access to information, and expertise. This is Guiding Principle number 26. Non-judicial remedies for business-related human rights abuses can be divided into state-based mechanisms and non-state-based mechanisms. They should complement rather than replace or undermine judicial mechanisms. State-based non-judicial mechanisms include, for example, national contact points under the OECD Guidelines for Multinational Enterprises, state-run ombudsman offices, and national human rights institutions. In addition to state-based non-judicial mechanisms, the guiding principles emphasise the importance of non-state-based grievance mechanisms. These could be, for example, mechanisms provided by an industry association, a multi-stakeholder group, or a company such as a company ombudsman or complaints procedure. They could also include regional and international human rights bodies. Finally, Guiding Principle number 31 outlines 8 effectiveness criteria for non-judicial grievance mechanisms. They should be legitimate, accessible, predictable, equitable, transparent, rights compatible, a source of continuous learning, and engagement and dialogue based. Apart from the UN Guiding Principles, there are a number of other principles that set standards to address the adverse human rights impacts of companies. Indeed, there are several voluntary initiatives addressing business and human rights related issues in different sectors and regions. Some examples include, first, the UN Global Compact. Before the adoption of the UN Guiding Principles, the UN embarked on an effort to address the adverse impacts on the corporate sector, leading to the eventual development of the UN Global Compact in the year 2000. The Global Compact established 10 non-binding principles to guide businesses in the development of socially and environmentally sustainable practices. Second, the voluntary principles on security and human rights. Building from the UN Guiding Principles, and as a collaborative effort by governments, major multinational extractive companies, and NGOs, the voluntary principles on security and human rights provide guidance to companies on steps that they can take to minimise the risk of human rights abuses in communities located near extraction sites. And third, the Global Network Initiative. It's a multi-stakeholder initiative which aims to protect and advance freedom of expression and privacy in the ICT sector by setting a global standard for responsible company decision-making and by being a leading voice for freedom of expression and privacy rights. Thank you for joining us during this first webinar. In the next one, we'll be looking at the links between business and human rights and the digital environment. Finally, in the third and fourth, OTI will be looking at the key issues of privacy and freedom of expression.